Hello friends, today I will start from section 12 of Evidence Act. I am reading the section. Section 12. In suits for damages, facts tending to enable court to determine the amount are relevant. In suits in which damages are claimed, suit for damages. In suits in which damages are claimed, any fact which will enable the court to determine the amount of damages which ought to be awarded is relevant. So, in a suit for damages, any fact by which the court can determine the quantum of the damages that should be awarded will be treated as relevant. This section enables the court to admit any fact which will help it to determine the quantum of damages which ought to be awarded to a party. This section is very easy and very simple. So I am coming to the next section 13. Facts relevant when right or custom is in question. Very interesting. Where the question is as to the existence of any right or custom, the following facts are relevant. A. Any transaction by which the right or custom in question was created, claimed, modified, recognized, asserted, or denied, or which was inconsistent with its existence. B. Particular instances in which the right or custom was claimed, recognized or exercised, or in which its exercise was disputed, asserted, or departed from. Before explaining the section, I am reading the illustration part. The question is whether A has a right to a fishery. A deed conferring the fishery to A's ancestors, a mortgage of the fishery by A's father, a subsequent grant of the fishery by A's father, irreconcilable with the mortgage, particular instances in which A's father exercised the right or in which the exercise of the right was stopped by A's neighbor are relevant facts. Now I am coming to the section again, where the question is as to the existence of any right or custom. Only right or custom are discussed here. The following facts are relevant. Any transaction by which right or custom in question was created by virtue of any transaction, if there is any transaction by virtue of which the custom or right was created, claimed, modified, change in the custom or right, recognized, asserted, affirmed, or denied, or which was inconsistent with its existence. I am giving one or two very simple examples. I am residing in plot A, and from my residence, that means plot A, whenever I have to go to the main road, I have to walk through plot B, which belongs to Mr. Ram. Because my plot has no direct access to the main road. I have to walk through the plot B, which belongs to Ram, to access the main road. and I have been using plot B, that means Ram's plot, for accessing the main road since long, and Ram never objected it. It is my right, asserted, recognized and created. Now Ram obstructed me. Ram constructed a boundary so that I cannot access the main road by using his plot, through his plot. So he denied my access. He denied my right. Now I am coming to the point of custom. Few things I have to tell you before I proceed regarding custom. There are few characteristics for a custom. A custom to be recognized by a court should be: 1. Ancient. It must be in use for long, since long. Continuous and uniform. Reasonable. Sotitaho was in practice since long, but it is not reasonable, so it is not a custom. Saptapadi in Hindu marriages are in use since long, and it is reasonable and it is uniform and continuous in every Hindu marriage, so it is a custom. Number 4, certain. 5, compulsory and not optional. For every Hindu marriage, marriages which are performed as per the rites and rituals and customs of Hindu marriage, Saptapadi is a mandate, a mandatory custom for Hindu marriage. So it is not optional. I cannot say that I will perform a marriage, I will perform a Hindu marriage, but I will not perform the Saptapadi. It is not optional, it is mandate for every Hindu marriage. If I want to do Hindu marriage, I have to perform the Saptapadi. Peaceable. If it is to be recognized as custom, it should be peaceable, peaceful. Sacrifice of children before the goddess or something like that was in practice since long, but this is not peaceful, this is not reasonable, though it was in use since long, but it should not be entertained, recognized as custom and not immoral. So there are 7 characteristics for a custom. I am again reading: ancient, continuous and uniform, reasonable, certain, compulsory and not optional, peaceable and not immoral. So if a particular performance is to be treated as custom, if I want the court to treat a particular performance as custom, these 7 characteristics have to be followed. Unless these are fulfilled, court will not accept the particular performance as custom. Now if I go to this section again, a particular instances in which the right or customs was claimed, recognized or exercised, or in which its existence was disputed or asserted, either disputed or asserted or departed from, are relevant. I have performed a Hindu marriage, but I departed from the mandatory custom of Saptapadi. This is relevant in any case concerning that particular Hindu marriage. I hope I could make section 13 clear to you. Now section 14, which is very important, and it will take a bit time to explain the entire. Section 14, read with me. Facts showing existence of state of mind or of body or of bodily feelings. Facts showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will or good will, not goodwill, but please note the term good will, towards any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or body or bodily feeling is in issue or relevant. In issue means fact in issue. Explanation 1. A fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists, not generally, but in reference to the particular matter in question. I am not explaining this right now. I will explain the entire section again after discussing the illustrations. That will help you to understand this section more easily. Explanation 2. But where, upon the trial of a person accused of an offense, the previous commission of the accused of an offense is relevant within the meaning of this section, the previous conviction of such person shall also be a relevant fact. Now I am coming to the illustrations. Illustration A. Read with me. A is accused of receiving stolen goods, knowing them to be stolen. It is proved that he was in possession of a particular stolen article. The fact that at the same time he was in possession of many other stolen articles is relevant. Why it is relevant? It proves that A is dealing with stolen articles. A is in habit of purchasing stolen articles, as tending to show that he knew each and all of the articles of which he was in possession to be stolen. So, previous acts which shows the intention, the action, knowledge of the accused is relevant in this way when that shows the knowledge or intention of the accused. Illustration B. A is accused of fraudulently delivering to another person a counterfeit coin, which at the time when he delivered it, he knew to be counterfeit. With the knowledge that the coin is counterfeit, A delivered the same to another. The fact that at the time of its delivery, A was possessed of a number of other pieces of counterfeit coin is relevant. A gave me one counterfeit 100 rupees note. One. and A had knowledge that the particular note is not genuine, counterfeit note. But at the time when A handed over to me the particular counterfeit note, at that point of time, A had in possession many other counterfeit notes of similar nature. This is relevant. Why? The fact that at the time of its delivery, A was possessed of a number of other pieces of counterfeit coin is relevant. The fact that A had been previously convicted of delivering to another person as genuine a counterfeit coin, knowing it to be counterfeit, is relevant. Why it is relevant? Because it is well within the knowledge, it is the intention of the A to push into the market the counterfeit currency with the knowledge that these are all counterfeited currencies. And also it is relevant that in a previous case, A was convicted for marketing, for pushing into market, for possessing counterfeit notes. So this shows that A's intention is to use the counterfeit note with the knowledge, and it is the ill will of A. What is the ill will? A wants to push into the market the counterfeit notes, currencies. This is the ill will. Coming to illustration C. A sues B for damage done by a dog of B's, which B knew to be ferocious. The fact that the dog had previously bitten X, Y, and Z, and that they had made complaints to B are relevant. Very nice example. A sues B for damages done by B's dog. B had the knowledge that his dog is ferocious, and it is also fact that the dog has the history of biting X, Y, and Z previously, and it is within the knowledge of B that his dog bitten the X, Y, and Z. So these previous incidents are relevant. Why? Go to the section. This is under negligence, rashness. It will become relevant. Illustration A and B describes intention, knowledge, ill will. Illustration C describes negligence, rashness. Now coming to illustration D. The question is whether A, the acceptor of a bill of exchange, knew that the name of a payee was fictitious. The question is whether A, the acceptor of a bill of exchange, knew that the name of a payee was fictitious. The fact that A had accepted other bills drawn in the same manner before they could have been transmitted to him by the payee, if the payee had been a real person, is relevant, as showing that A knew that the payee was a fictitious person. Ill intention, ill will. Go to the section. Ill will. After the word rashness, you will find the word ill will. This illustration D explains the word ill will in the section. Now, illustration E. A is accused of defaming B by publishing an imputation intended to harm the reputation of B. The fact of previous publication by A respecting B, showing ill will, on the part of A towards B is relevant as proving A's intention to harm B's reputation by the particular publication is in question. Ill will. The fact that there was no previous quarrel between A and B and that the fact that there was no previous quarrel between A and B and that A repeated the matter complained of as he heard it are relevant as showing that A did not intend to harm the reputation of B. I am again reading the last part of the illustration E. The facts that there was no previous quarrel between A and B, there was no enmity, nothing, and that A repeated the matter complained of as he heard it are relevant as showing that A did not intend to harm the reputation of B. If A is sued by B for fraudulently representing to B that C was solvent, whereby B being induced to trust C, who was insolvent, suffered loss. A had no good intention. A is sued by B for fraudulently representing to B that C was solvent, whereby B induced to trust C, who was insolvent, suffered loss. Who suffered loss? A. Why? Due to B. B misrepresented C that C is solvent, whereas C is not at all solvent. And upon this inducement made by B, A gave some money to C and suffered loss. The fact that at the time when A represented C to be solvent, C was supposed to be solvent by his neighbors and by persons dealing with him is relevant as showing that A made the representation in good faith. Now, there is a change. C was induced as solvent when C was not at all solvent. But if the matter is that when C was introduced as solvent, he was known by his neighbors and others, by his acts and activities and everything, that C was solvent. No one could think that C was not solvent. C has a huge car, a huge bungalow, lots of things. So neighbors and others who are well known to C, they thought that C was very much solvent. And that's why C was introduced to A, that C is very much solvent. Though C is not solvent, this is also relevant. Now I'm coming to illustration G. A is sued by B for the price of work done by B upon a house of which A is owner by the order of C, a contractor. A is sued by B for the price of work done by B upon a house which is owned by A by the order of the C. What is the status of C? C is the contractor. A's defense is that B's contract was with C. A took the defense that you cannot sue me because you had the contract with B, not with me. The fact that A paid C for the work in question is relevant. A made some payment to C. It is relevant. As proving that A did in good faith make over to C the management of the work in question, so that C was in a position to contract with B on C's own account and not as agent for B. Agent for A. I'm sorry. Again, I am reading this part. The fact that A paid C. A is the owner. A directly made payment to C for the work in question is relevant, as it is proving that A did in good faith make over to C the management of the work in question, so that C was in a position to contract with B on C's own account and not as agent for A. Clear, I think. Next, illustration H. A is accused of the dishonest misappropriation of property which he had found, and the question is whether when he appropriated it, he believed in good faith that the real owner could not be found. The fact that public notice of the loss of the property had been given in the place where A was is relevant. Whether it is within the knowledge of A or not. A is accused of dishonest misappropriation of property which he had found, and the question is whether when he appropriated it, he believed it in good faith that the real owner could not be found. Now, the fact that public notice of the loss of the property, I put a public notice in our newspaper in some crowded areas. The fact that the public notice of the loss of the property had been given in the place where A was is relevant. Why it is relevant? As it is expected that A should notice the public notice, and it should be well within the knowledge of A that the property was lost. The fact that A knew or had reason to believe that the notice was given fraudulently by C, who had heard of the loss of the property and wished to set up a false claim of it, is relevant, as showing that the fact that A knew of the notice did not disprove A's good faith. I am reading again. The fact that A knew or had reason to believe that the notice was given fraudulently by C. Notice was there, but A had reason to believe that the notice was fraudulently given by C. A saw the notice, but had reason to believe that the notice is forged, fraudulently given by C. who had heard the loss of the property and wished to set up a false claim of it is relevant, as showing that A did not in good faith believe that the real owner of the property could not be found. Now I am coming to illustration I. A is charged with shooting at B with the intent to kill him. In order to show A's intention, the fact of A's having previously shot at B may be proved. The allegation is A fired at B. Previously, A also tried to murder B by firing. It is relevant because it shows A's intention. A intends to murder B. Illustration J. A is charged with sending threatening letters to B. Threatening letters previously sent by A to B may be proved. In a last letter dated 10th May 2022, A threatened B that I will murder you. This letter is in question. Case has been filed based on this letter. Now in this case, previous letter written by A to B on 1st January 2021 that I will cause harm to you is relevant. Though this letter was written more than a year ago, but this letter shows that A has the intention to cause some harm, shows the intention, ill will of A. Illustration K. The question is whether A has been guilty of cruelty towards B, his wife. B is the wife of A. Expressions of their feeling towards each other shortly before or after the alleged cruelty are relevant facts. This is a very nice example, and you will find cases based on this illustration in any court on any day. Basically, when we appear as a defense lawyer in any matrimonial torture case, we take the aid of this illustration and this section. Allegation of the wife is, I have been tortured by the husband in the matrimonial home in such and such way, very much tortured, etc., blah blah blah, many things. But we start cross-examining the wife, whether you had gone to honeymoon, whether you both went to dine in any restaurant, whether you went for any outing, whether you attended any social function, everything. We put small questions in the cross-examination of the wife with the anticipation to find answers from the wife that before the date of incident, the relation between the parties was very cordial. Now, illustration I. The question is whether A's death was caused by poison. The statement made by A during his illness as to his symptoms are relevant facts. This is very simple. The question is whether A's death was caused by poison. Medical report will be there, medical report will suggest many things, etc., etc. Those are fine. But statements made by A during his illness as to the symptoms. What was his problem? Burning sensation in the throat, burning sensation in abdomen, vomiting. All these were told by A. So these are relevant. Illustration M. The question is, what was the state of A's health at the time when an assurance on his life was effected? Statements made by A as to the state of his health at or near the time in question are relevant. Statement of the A when the assurance was given, statement of the A about his health are relevant. These are basically used in insurance matters, medical matters. Many times our mediclaims get rejected as on the ground that these are pre-existing disease, and you fail to mention all these diseases at the time of applying for mediclaim. So we can use these illustration to support our mediclaim if the mediclaim is refused. Illustration N. A sues B for negligence in providing him with a carriage for hire not reasonably fit for use, whereby A was injured. The fact that B's attention was drawn on other occasions to the defect of that particular carriage is relevant. The fact that B was habitually negligent about the carriages which he led to hire is irrelevant. Here, the negligence of B is not relevant. What is relevant? The fact that B's attention was drawn on other occasions to the defect of that particular carriage. B taken this carriage on hire on 10th May 2022. The carriage was defective and B suffered some injuries due to that defect. B took the same carriage on 1st May, and on 1st May the defect of the carriage was identified to be. At the time of hiring, at the time of letting out, B was notified that the carriage is not in a good condition. Its doors are not locking properly, and despite that, B took that carriage on 1st May, and again he took that carriage on 10th May. So it is well within his knowledge that the carriage is not fit or not good and the carriage is defective, and out of that defect he receives some injuries. So this previous knowledge is relevant. But the negligence of the carriage owner that he rents out defective carriage is not relevant. Illustration O. A is tried for murder of B by intentionally shooting him dead. The fact that A on other occasions shot at B is irrelevant as showing his intention to shoot B. I explained it earlier. The fact that A was in habit of shooting at people with intent to murder them is irrelevant. A's previous shooting at B to murder B is relevant, but A is in the habit of shooting other people's is not relevant. Why it is not relevant? Now the question comes here. Why the previous shooting at B is relevant and why the previous shooting at other people's are not relevant? Question comes here. The case is murder of B by A by firing. Here, previous firing by A to B will prove the intention of A, that A wants to murder B. So this is relevant. But A's habit to shoot other people's are not relevant, because that habit does not explain anything in connection with this case. Last illustration, that is P. A is tried for a crime. The fact that he said something indicating an intention to commit that particular crime is relevant. A murdered B and is under trial. The fact that A told me that I will murder B, it is relevant because it shows the intention. The fact that he said something indicating general disposition to commit crimes of that class is irrelevant. A told me that I will murder B, that is relevant. A told me that I will murder is not relevant. Whom to murder? So, when A says I will murder B, that is relevant in the case of murder of B by A. But when A said that I will murder, A did not say whom he is going to murder. That is not relevant. Now I am coming to this section again. Please read with me line by line. Facts showing the existence of any state of mind. I will murder B. State of mind. As an intention, knowledge, good faith, negligence, rashness, ill will, or good will towards any particular person, or showing the existence of any state of body or bodily feeling are relevant when the existence of any such state of mind or body or bodily feeling is in issue or relevant. I think after discussion of the entire illustrations, the section is clear to you. Explanation 1. A fact relevant as showing the existence of a relevant state of mind. I will murder B. Must show the state of mind exists. Not generally. I will murder B. Not I will murder. Not general. I will murder. It is general. But specific. I will murder B. But in reference to the particular matter in question. I am reading again. A fact relevant as showing the existence of a relevant state of mind must show this state of mind exists, not generally, but in reference to the particular matter in question. When the trial is, when A is facing the trial of murdering B, the statement should be, I will murder B, not I will murder. I will murder is general. I will murder B is specific. Explanation 2. But where upon the trial of a person accused of an offence, the previous commission of the accused of an offence is relevant within the meaning of this section, the previous conviction of such person shall also be a relevant fact. See the illustration of counterfeit. I am going to it. Just a minute. Where is the counterfeit? Just a minute. Illustration B. A is accused of fraudulently delivering to another person a counterfeit coin, which at the time when he delivered it, he knew to be to be counterfeit. Okay, the fact that at the time of delivery A was possessed of a number of other pieces of counterfeit coin is relevant. Okay, now the fact that A had been previously convicted of delivering to another person as genuine a counterfeit coin, knowing it to be counterfeit, is relevant. That conviction itself is relevant. I am reading explanation 2 again before ending this episode. But where upon the trial of a person accused of an offense, the previous commission of the accused of an offense is relevant within the meaning of this section, the previous conviction of such person shall also be a relevant fact. I think up to section 14 I could make the evidence up to section 14 clear to you. If you have any questions, any doubt, feel free to write to me or call me directly. I will be very happy to reply to your emails. I am thankful to all of you who took the pain to write to me to give feedback of these video sessions. Thank you. Stay blessed. My next video episode will be uploaded very soon. I will start from section 15 in the next episode. Thank you. Stay blessed.